One moment, Judge. We'll be live momentarily.
Has it stopped raining in Austin?
Started again this morning.
We are live, Judge.
Thank you. We are here for a pretrial conference in the special Court of Review hearing involving Senator Sarah Eckhardt, ex-Travis County judge. And the panel, the reviewing panel, consists of Justice Stacy Trotter from the Eastern Court of Appeals, Justice Charles Krieger from the Beaumont Court of Appeals, and myself, Brian Quinn, from the Amarillo Court of Appeals. And at this point, I would like the counsel to identify themselves, please. And if we can start with those representing the state, so to speak.
Sure. Thank you, Chief Justice Quinn. My name is Michael Graham. I'm the General Counsel for the State Commission on Judicial Conduct. I'll be lead counsel for the examiners, and I'm joined by Ms. Lauren Hayes, who is Senior Commission Counsel here at the Commission.
Thank you.
Judge, I'm James Kauser, Thompson and Knight, Austin, Texas, appearing for respondent Senator Sarah Eckhardt.
Thank you, counsel. Let's begin with trial dates. The panel has discussed the possibility of a Zoom versus in-person. The panel would like to have an in-person hearing. We find 7th Court of Appeals is back to in-person hearings, and we've been back since April. And believe it or not, I've changed my views about in-person things. I find that you can get more done, and it seems to be more conducive to having a give and take between the parties in the court, as opposed to just looking at a flat screen. And if the other justices want to voice in, please do. I don't mean to take up the whole proceeding myself, but that is how we're leaning to it right now, is in person. We would entertain good cause not to have that, but that's where we're heading. I will open it up to you guys. Any good cause objections?
The Commission doesn't have any objections, Chief Justice. We'll do it either way, but we don't have any objections to an in-person hearing.
And Judge, that's actually our preference, is to have a live hearing.
Okay, good. We will, just like we did for our court, in fact, we had 2 weeks ago, we had the hearing in person in the 3rd Court of Appeals in Austin, in the transfer case. So just as we did there, we will put together some health protocols, and we will make sure that they're followed there, hygiene, sanitizing wipes, things like that. So to reduce any risk of disease or virus or anything like that. So we'll take those steps. Well, great. We will have an in-person hearing. We were looking at trial times. We're looking at also having it in Austin, where the judges would be traveling to Austin, as opposed to traveling elsewhere. The statute doesn't say where it has to be. It's just a selection of the panel, but we're looking at Austin. We are looking at the first week after July. July 4th, excuse me, first week after July 4th. Tentatively the 7th of July, but that week. What does it look for you, counsel, and your parties?
Well, for the Commission, that does pose an issue. We actually have an argument in the 5th Circuit on July 6th that I'm going to need to deal with. I won't be arguing it, but I may need to go to New Orleans for that. And so if we were thinking July 7th, that might cause me some issues. Obviously, I'm going to work as best I can with the court. But that's the one problem that I have with that week. I'll let you know that.
And Judge, on behalf of respondent, I don't think anyone other than the governor and his staff really know when the next special session is going to occur. But the speculation that I'm hearing in Austin is that the governor is probably going to convene a special session in the month of July. And obviously that can't be confirmed at this point. On a personal basis, I generally take, starting around the 4th of July, I take a 3-week family vacation to Colorado. And I'm currently planning to leave for Colorado just before the July 4 weekend and be up there for the next 3 weeks. So July would not be convenient for me, and it might not even be available for my client.
Okay. Okay.
I'm envious.
What, sorry?
You have an extra room?
Yeah.
The altitude's pretty high. It doesn't agree with everybody, but it's fine with me.
What part of Colorado?
It's a little town called Allen's Park that's right on the edge of Rocky Mountain National Park, near Estes Park. It's really a village.
Well, very good. It's nice to get away. Very, very nice to get away. One of the things that we were wondering about was a special session. We heard those rumors for a long time, and the governor talking about it as well. And we were wondering if it was going to be more in fall. So I'm glad that you broached that topic of the special session. And of course, if there is a special session, that throws kind of a monkey wrench in it, given the legislative continuance statute that would be involved. Let me ask this of counsel. The statutes generally provide that when the state has filed their charges, so to speak, in a review, there's 30 days to have a hearing. Is that right, Mr. Graham?
Yes, Chief Justice, that is correct. And just to give you a little context, during the pandemic, we've had a number of courts of review that have essentially been put on hold, stayed, for lack of a better term, pursuant to the Supreme Court's emergency orders that have allowed courts to kind of play with the rules and deadlines. We've just taken the position that that applies as well to the proceedings in these courts of review, though the order it's not explicit on that fact. I can tell you that the commission is not going to challenge jurisdictionally any of these sorts of things. We want to be as flexible as we can given the circumstances, and we want Senator Eckhardt to have her chance at a full appeal and let this court of review have a chance to make its decision. So, we're going to work with the court as best we can in terms of that. I guess that's a long-winded way of me saying I think that we can deal with the obstacles or potential obstacles that might be posed by the statute in more normal times.
Is the 30-day, and I think I know your answer, but is the 30-day provision jurisdictional? It's never been challenged to my knowledge. I think it would be. The statute also provides for a 60-day continuance on top of that. Right. And so typically what happens in courts of review, almost as a matter of course, is that they get extended the full 60 days or close to it, even in normal times, so that from the charging instrument being filed to the date of the actual hearing usually is in about the 90-day range. Okay. Mr. Counsel?
Counsel, Judge.
Counsel. Do you have any position on that?
We'd concur that I don't think it's jurisdictional, and I agree with Mr. Graham that the Supreme Court's orders basically give the Special Court of Review flexibility not to comply with that deadline.
So what I'm hearing right now is save for a special session being called. The earliest we're looking at is sometime in August.
Yeah, Chief Justice. In fact, Mr. Kauser and I spoke at length about this issue and others yesterday, and we were sort of aiming for August, based, of course, and basing it on what the court was going to have to say. But that's where we were looking.
Can you give us several dates in August so the judges can get together and compare those dates with our own schedules, and we can select one?
Sure. Let me tell you, for the commission, the only the only fly in the ointment for August is we have an August meeting, and that takes place on, let me look at my calendar here. We'll have a Zoom portion of that on Friday, August 6th, and then our in-person commission meeting is August 11th through the 13th. So for me and Ms. Hayes, those should be the only days that would be difficult for us. Any other days in August, we can probably manage.
And
Let me do
judges,
I'm sorry, go on.
I'm going to say it's going to sound like all I do is go on vacation, which is not really true, especially in the past year, but I'm attending a family wedding in New England that will take me from, I think, August 11 to about August 18 or 19. I don't have the exact dates before me, but that's basically more or less the middle 10 days of August. So if we're going to do this in August, the best week for me would be the last week of August.
Let me ask you to do this. Go on and encapsulate what you just said, both sides, and send it in an email to Claudia Jenks, please, because I will not remember what you said. I didn't write it down, even though it's recorded. I'd like to see it in writing, if you don't mind. That way we can send it to the judges too, and we can get together then.
You bet, Your Honor, no problem.
The venue that we were looking at to conduct this was is the Third Court of Appeals. There is a problem now with that that I discovered this morning. They are having to renovate the lighting inside the Third Court of Appeals, and it's starting in July and will run through August. So that means it will be unavailable for those 2 months. If we have this in August, if there's no special session, we have this in August, we'll need to find a venue. One of the places I'm thinking of, and Claudia, I'm sorry.
Chief,
Yes,
no,
ma'am.
Chief, I was gonna tell you, if it's gonna be in August, I can ask my clerk to see if we can have a hearing there. I mean, they haven't really told me for sure if we can have hearings, but I know they're gonna have in-person oral arguments starting in September. So maybe they'll allow us to use the courtroom in August, but I just need some dates just to let the clerk know and find out.
Okay, well, that'd be good, because one of the other venues we're thinking about was calling the Court of Criminal Appeals right across the hall, and seeing if that was available, and if not, then I know there's a moot courtroom that's big enough for a panel of appellate judges at the UT Law School, and when the Seventh Court has traveled to hear transfer cases, we often sit at law schools because of the courtrooms. So that was one of the other venues. But Ms. Jenks, if you could check on, well, we'll get you those dates, and then we can start with the Supreme Court first, and then work around that. Okay.
I will do that. I'll actually email my clerk right now and see if August, anytime in August will be available.
Okay. That'd be
Thank
great. That'll be great. So let's look at potential August date. We'll get you those dates, post dates. This is, just to confirm, this was an informal proceeding which requires a de novo review. Is that?
That is correct, Chief Justice Quinn.
So we're looking conceptually like a trial. Evidence, is there any, since you've been through this once in front of the commission, do you have all your evidence ready?
Judge, let me speak to that. We would anticipate presenting the senator as a live witness, and then probably two other live witnesses. One would be a former member of the Commissioner's Court, Gerald Doherty, who served with Senator Eckhardt when she was county judge and when she was a county commissioner, and who was present on January 24, 2017, when the episode took place where the senator wore the hat at a commissioner's court meeting. And the other witness we would plan to present is the current judge of the Statutory Probate Court #1 of Travis County, Judge Guy Herman. And most of his testimony we anticipate would be about the role historically of the county judge and the county courts at law in Travis County, including the Statutory Probate Court. Judge Herman's been on the bench here since the early 80s and has a lot of personal knowledge about how that's evolved.
And forgive me for my ignorance. It's been a long time since I've sat on one of these panels. Does the commission go first?
Yes, Your Honor. The commission has the burden of proof in this case.
That's what I thought. Just wanted to make sure. And let's go back to Mr. Counsel. How long do you think, since you've already started talking about your witnesses, how long do you think it will take you to present your side?
Probably less than 30 minutes for the senator, and probably about 20 minutes each for the former commissioner and for Judge Herman. So combined, say maybe more than an hour, less than an hour and a half.
And I'm assuming with regard to documents, exhibits, you have those all put together?
They are, I'd say they're 90% assembled, Judge. There may be some additional documents relating to the what was called the Texas Tribune Festival in 2019, where Senator Eckhardt appeared on a panel. I think I've pulled together everything I can get off the public record for that, but there may be some other documents that are actually in the possession of the senator of the Texas Tribune that I'd want to present. But total exhibits, I think we're looking at less than a dozen, other than what's already been entered in the record before the committee. Well, it's not really a record, but what went into the hearing before the commissioner.
In your discussions yesterday with opposing counsel about this, did you talk to him about the exhibits? Does he know what you're going to be doing?
We did discuss that, and certainly Mr. Graham should speak for himself, but my impression is there's no objection to the exhibits we would present from the Commissioner's Court hearing in 2017 and the Texas Tribune Fest in 2019. And the other thing that Mr. Graham and I discussed is basically entering the hearing record and documents from the commission as stipulated exhibits. I know this is not a review of substantial evidence on the record, but probably everything that came in before the commission is relevant.
And I'll just follow up, Chief Justice Quinn. I can't imagine that I would have any objections. I mean, without seeing exactly what Mr. Kaiser's talking about, but I think there's not going to be much in the way of objection. And we're also going to try, I think, to be able to enter some stipulated facts and stipulated exhibits, basically that I hope will help make the hearing more efficient for y'all and for us too.
Well, good. That's one of the topics I wanted to broach, was the chances stipulated facts, kind of smooth things along. Would it be possible to get both sides to exchange whatever exhibits and whatever evidence they propose to tender by the end of July? That way, that'll give them opportunity to see it, see the opposing evidence exhibits and raise any objections, and give us opportunity to address those pre-trial, if you will. July 31st is okay. I know you're going to be vacationing, but counsel, but you
I
still
should be
got some
back.
time between now and then.
I should be back by then, Judge.
Okay,
I'm sure we'll be able to work that out, Chief Justice.
okay. That sounds good. Let's go back, Mr. Graham. Well, first of all, Mr. Cowser, do you have anything else that you'd like to mention with regard to evidence, witnesses, exhibits?
I think we've covered it, Judge.
Mr. Graham?
No, just to let you know, I mean, in terms of witnesses, I imagine the only witness that the commission will call will be Senator Eckhardt. And I doubt that we will spend too much time with her. I wouldn't think more than 30 minutes total.
Okay. Okay. Judge, do you have any questions so far? Any observations? I know, Judge Trotter, you've been at least compared to me, you've been the one that's most recently tried a case. So I would appreciate whatever observations or questions you may have.
Well, I'm glad that everyone is in agreement to have in person. It'd be a better forum for everybody to get this presented. And I'm very pleased that the attorneys have been working well with each other. I love that, because so often in the trial practice, you see that the attorneys make an effort to not get along. So I commend you for your professionalism. And I'm glad that everyone's unavailable for August 11th, because that's my anniversary. And if I was in court on that day, I'd be sleeping outside for a while. So thank you for all being unavailable then.
You bet.
Justice Krieger, anything?
No, I'm good. I think we've covered everything that I need.
Just a quick question. Any motions that you foresee being filed pre-trial?
Judge, if I may speak to that, both sides did briefing several months ago, and one of the issues raised in respondent's brief was the question of jurisdiction. One issue of jurisdiction certainly would be based on legislative immunity, and the second issue of jurisdiction would be whether the commission may properly exercise jurisdiction over a county judge who's never carried out a judicial function. And we would like to file a plea to the jurisdiction to be considered by the court before this matter goes to trial.
When do you think that? Well, let me do it this way. Could you get that filed before you go on vacation?
Absolutely, Judge.
And did you discuss that with Mr. Graham, or is this something needed? Okay, he's nodding his head yes. How fast could you get a response to that, Mr. Graham?
Within a week or two, tops.
How about 10 days? Well,
10 days would work.
cut the butter, 10 days.
There you go. 10 days would work.
Okay. And so you're looking at going on vacation the week after 4th of July. So
It's actually, Judge, I would be leaving probably on the Thursday, July 1. So, if we set the time to file the brief by June 30th, I think that would be fine.
I'm sorry, you just cut out, or I'm going deaf, but can you say that again, the date?
My planned day of departure is June 30th. I'm sorry, July 1.
Okay.
So I'm suggesting June 30th for the filing of the brief.
Okay.
And the motion, I mean.
Okay.
Plea to the jurisdiction.
We'll look at June
I have to
30th.
step away for just a moment. Y'all go ahead and continue.
We'll look at June 30th as the day for you to file your motion. Mr. Graham, I know that you've got this great trip planned to go to New Orleans within 10 days after that.
Could we go with Monday, the 12th for a response?
Justice Krieger, you have any problem with that?
Not at all.
Okay, so let's do the response on the 12th.
Thank you, Your Honor.
Mhm. And I'm assuming you're going to treat this as a regular plea to jurisdiction. Justice Strider, the state will file their response on the 12th of July to the putative jurisdiction. Assuming it's filed, I'm not saying it won't be, but you will treat this as a regular putative jurisdiction, attaching whatever exhibits and affidavits, et cetera, et cetera.
That's correct, Judge.
Okay. Then the panel will proceed and resolve that in due haste.
And sir, from the standpoint of your pleaded jurisdiction, will it be challenging the jurisdictional facts, or will it be a pleadings only challenge?
It will be based on the pleadings. It will be supplemented by documentation and affidavits about the events at the Commissioner's Court hearing in 2017 and the Texas Tribune Festival in 2019. I don't think it will be any facts that are contrary to what the commission considered. It will just be, additional evidence about what took place at those two events and providing context.
Would it be possible for you and Mr. Graham to get together and see if you can stipulate those facts to that evidence and its admissibility, et cetera, et cetera?
Certainly, Judge, we can do that. One of the things that I can also provide that we would include as an exhibit is the video record of the Commissioner's Court hearings in 2017. And if my technology people can assist me in sending, we've already taken that recording and got it on a hard drive. If we can figure out how to get that over to Mr. Graham in a convenient way, then the rest of it is just paper.
And I assume the video would relate to whether or not the senator was performing a judicial function at the time.
That would be relevant. And I think it would highlight the legislative nature of what the Commissioner's Court was considering at the time that she had the hat on, which was a resolution that actually was considered 1 week and then reworked and brought back another week.
Okay. Any other motions that either side are considering at this time?
Not for the commission, Your Honor.
Nothing else, Your Honor.
We've talked about generally the time of trial, the length of trial, the evidence, witnesses. Sounds like we can, if we do have a trial, assuming your to the jurisdiction is not well taken. If we do have a trial, it can be done in a day. Of course, if your pleaded jurisdiction is well taken, there will be no trial. We talked about motions. Judges, anything else you think we need to broach in this pretrial conference? Anything the parties want to broach?
The only thing I would mention, Chief Justice, is that typically when we have these courts of review, we have some post-submission briefing that's done by the parties. Typically, it's a brief from the commission within 2 weeks of the hearing. Well, maybe a little longer depending on transcripts. And then within 2 weeks of that, a response from the respondent judge, and then a reply from the commission if the commission so desires. I'm just throwing that out there as that's typically how these things go, and I'd take the panel's temperature on if they would expect something like that.
Well, I've learned that I could always use help, and the judges, I'm sure, would be open-minded to talking about that. Let's wait until we see if post-submission briefs will be needed before we address that.
Sure.
I guess one thing that I wanted to address too, even in the live in-person proceedings of the Seventh Court of Appeals, we've continued to broadcast them on YouTube, kind of following the Supreme Court's lead of general open courts, universal wide, where they broadcast their oral arguments. My penchant would be to do that. I haven't talked to the other judges about this, and if you have a problem, let me know. But we are going to be, we're looking at in person. But my penchant would be to have a YouTube type thing, just so people can see it. Would anybody object to that?
No objection. In fact, I'll tell you all that this is the first in-person court of review we've done since the pandemic. We've had 2 Zoom court of reviews, and both of those were live streamed on YouTube. So the commission has no objection to that.
No objection on our part.
And I guess I should have asked the judges first before I did that. Maybe they'll smack me.
I don't object either. So.
At all. Okay. If there's nothing else from the council or the judges, I guess we can go on and end this pretrial conference and await the plea to the jurisdiction and whatever other matters that may arise. We will go on and work on getting dates too for the hearing, and we will work on getting a location for to send to you. That said, appreciate your attendance, appreciate your willingness to participate with Zoom, and look forward to discussing matters with you in the future.
You bet. Thank you all very much.
And with that,
Thank you as well.
adjourn.
Thank you all.
Have a good week.
You too.
You too.
Bye-bye.